This is exciting. If you've been at our previous two conferences, a topic that we haven't hit is postmortem, and what exactly is involved with oversight of postmortem operations. So that is something that we're going to focus on today. Just need to get through these. Okay, so I'm just going to give you a little bit of information about some interesting stuff in my state, Maryland, where I'm the director of the Maryland State Police Forensic Sciences Division. There really are, in Maryland, actually one of the places that there is a history of oversight. There is regulatory oversight, advisory oversight, and investigatory oversight. There are examples of all of these things, and I just want to touch on those before we get into our speakers. So in regards to regulatory oversight, there was the Postmortem Examiners Commission, and this goes way back. This was established in 1939 as the Department of Postmortem Examiners, and later changed to the State Postmortem Examiners Commission in 1982. Maryland is the oldest medical examiner system in the country, so this goes way back. What this involved was a 5-person commission that was basically responsible for all operational decisions, protocols, and key staff positions. And it included, by statute, Baltimore City Health Commissioner, the University of Maryland Medical System Head of Pathology, and the Johns Hopkins Head of Pathology, as well as the Maryland State Police Superintendent, and an Maryland Department of Health representative appointed by that secretary. So they really controlled the operations of the state medical examiner's office. Just recently, and when I say recently, just 2 years ago in 2023, this changed, and it became the Postmortem Examiners Advisory Committee. So more of going from regulatory to advisory was the way that this turned out. So what it did was it empowered the OCME to independently run their operations, where previously there was this commission that was making all of the decisions, and they were just slowing them down tremendously, hiring people, making changes to protocols, all things that are important, but it was very external. And I think that's one thing that this group's great about, is that we're combining lab directors with stakeholders, and I think that's where this sort of came out of. And basically, it's the same group that previously I mentioned. There's 5 positions, but it also added any other individuals that the Department of Health Secretary thought are appropriate. So it gives a little more freedom, and it's more an advisory role to guide. And then one thing that really isn't covered is, okay, what about investigatory oversight? And in the state of Maryland, those sort of things really fall to the Office of the Attorney General when something happens in the public that needs to be looked at. It's more of an ad hoc response, depending on circumstances. So in this case, we are going to tell you about an example that happened in Maryland that you may or may not have heard of, and it was based on a relatively famous and very public situation, but we just recently had a report on an independent audit of restraint-related death investigations at the Maryland Office of the Chief Medical Examiner from 2003 to 2019. So it's a very specific time. It's a very specific purpose, and it coincides with the time that Dr. David Fowler was the Chief Medical Examiner. So I think you're going to enjoy hearing about this, and we are lucky enough to have Dr. Jeff Kukucka, who is a professor of psychology at Towson University, and he's also the lead author on this audit report. And I can't say enough about Jeff. He's come to our lab a few times and given my staff some things to think about ethics and just he's a great speaker. I think we're going to love having Jeff here and telling you a little bit about what he went through. So, Jeff, pass it off to you.
Thank you, Dan. Thanks so much, Dan, for having me. I'm not that great of a speaker. Set your expectations low. As Dan mentioned, I'm a psychologist. I have served on the OSAC Human Factors Task Group for the past 6 years. And most recently, I oversaw this independent audit of in-custody deaths that I am going to share with you today. So for the next 30 minutes or so, I'm going to walk you through the impetus for the audit, which Dan just alluded to, tell you about the procedure that we followed, which, as you can imagine, was very painstakingly meticulous, tell you about the results of the audit, as well as the recommendations that we make in our report that stem directly from the findings of the audit. So the story starts in 2020. As we all know, in May 2020, George Floyd died in Minnesota while being restrained by several Minneapolis police officers. One of those officers, Officer Derek Chauvin, was later charged with Floyd's murder. At that murder trial, one of the key questions was, how exactly did Mr. Floyd die? Was his death a homicide, meaning did it result from the actions of the officers who restrained him? Or was it due to other factors or some combination of those things? At Mr. Chauvin's murder trial, there were a number of experts who testified for the prosecution that George Floyd's death should rightly have been classified as a homicide. But there was one expert, Dr. David Fowler, who Dan mentioned earlier, who testified in Mr. Chauvin's defense that George Floyd's death should rightly have been classified as undetermined, that it was not clear whether Mr. Floyd would have died were it not for the actions of the officers involved, because there were other factors at play. Now, Dr. Fowler served as chief of Maryland's Office of the Chief Medical Examiner, OCME for short, from, that's actually a typo, 2003 to 2019. And in light of this testimony that he gave in this obviously very high-profile case, there was a swift and fierce backlash to his testimony. What you're seeing here is a screenshot from an open letter that was co-authored by over 500 of Dr. Fowler's medical colleagues, in which they, in no uncertain terms, denounced Dr. Fowler's testimony. They said it was baseless. They said it was biased. They accused him of malpractice. And in that same letter, they called for an investigation into all in-custody restraint-related deaths that were investigated at Maryland's OCME during Dr. Fowler's tenure as chief. Basically, they were worried that the sentiments that he expressed at the Chauvin trial were characteristic of his work and that there might be other cases that had been misclassified. They were particularly concerned about the possibility that there may have been deaths that should have been certified as homicides, but were certified in other categories, which has not only obvious social justice implications, but also serious public health implications, right? In terms of identifying and addressing dangerous situations that can lead to preventable deaths. Then Attorney General Brian Frosch and now Attorney General Anthony Brown have supported this audit from day one, and they recruited a team of experts in forensic medicine, psychology, and research design, myself included, to oversee and execute this audit. The primary goal that we were given was to review OCME's determinations for in-custody deaths during this time frame and collect some data on whether those determinations were appropriate or inappropriate. The secondary aims that we were asked to design an audit to examine were whether there was any indication of racial and or pro-police biases in OCME's determinations. In other words, were they treating otherwise similar deaths differently as a function of the race of the individual involved or as a function of who was applying restraint in that particular case? Now, before we go any further, and I imagine I'm largely preaching to the choir here, but just so we're all on the same page, I want to make sure we're all clear on what are the determinations that a death investigator or a medical examiner is asked to make. And there are two of them, cause of death and manner of death. They're very different. Cause of death is a medical judgment of why a person died. Specifically, it is an articulation of the specific injury and or diseases or injuries that led to the person's death. So a gunshot wound and the damage that it causes, for example. Manner of death, on the other hand, is a more interpretive judgment of how the person died. And in the United States, it is classified in one of these 5 categories: natural, accidental, suicide, homicide, or undetermined. So if a person is found dead from a gunshot wound, the cause of death is very clear, right? The gunshot wound is what caused them to die. But then there is a second question, which is, well, how did that gunshot wound come about? Was it accidental? Was it self-inflicted? Was it other-inflicted? That requires more interpretation, more context in which to situate that decision. Now, as I mentioned in that letter that I showed you a few slides ago, a particular concern that was raised was whether there were misclassifications of what should have been homicides but were certified in other categories. So before we go any further, I want to make sure we're all clear on what the word homicide means in this context, because the word homicide in a medical context means something very different than what it means in a legal context. In a death investigation context, a homicide means, according to guidelines from the National Association of Medical Examiners, that the death would not have occurred but for the actions of another person. In other words, another person's actions, at least to some degree, contributed to the death. Those actions, however, are not necessarily criminal in nature, right? It doesn't necessarily imply criminal wrongdoing or liability. It just says this person would not have died if this other person had not done X. So that is an important distinction, that a homicide in a death investigation context is not necessarily a criminal act. Getting now into the procedures of the audit. This is something that, again, we painstakingly developed over years because we wanted to get it right. And the folks you're seeing on the screen here is most of the members of the team who collectively developed this audit procedure. Again, experts in forensic medicine and pathology, psychology, decision-making, research methodology from all over the country who put together their collective expertise. It wasn't always easy. We didn't always see eye to eye, but we ultimately developed a very well thought out procedure for making sure that we got the information that we were asked to get. And of course, the first thing we had to do is identify, well, what cases are even going to be included in this audit? So we cast a very wide net. We contacted Maryland's OCME. We asked them to provide us with summary information about every death in custody that they handled during the 17 years that Dr. Fowler served as chief. That was a lot of cases, right? It was just over 1,300 cases that they had categorized as deaths in custody. Now, as you may well know, the term death in custody is a very broad term, right? Any death that occurs while a person is somehow having their liberty restrained is considered a death in custody. So a person who suffers a heart attack while incarcerated, for example, a person who commits suicide during an arrest, those are not the sorts of cases that we were interested in here, right? We were interested in cases that circumstantially are similar to the death of George Floyd that precipitated this whole thing. So what we did is we went through those 1,300 some odd cases and we looked for indications that restraint had been used. That could be physical restraint, so weighted restraint, for example. It could be electrical restraint, the use of a taser. It could be chemical restraint, the use of a sedative. Some form of restraint was used. We identified 142 cases where there was some indication that restraint was used. We then circled back to OCME. We said, hey, can we have the complete case files? Give us everything you have about these cases, everything that the original investigator would have had access to. They were able to provide complete case files for 139 of those cases. We then scoured those case files to identify cases where restraint certainly was present. Right? Not necessarily that it was a factor. We obviously didn't make that judgment, but restraint was used. We ultimately ended up with 87 cases, all of which included a sudden or unexpected death that occurred during or soon after the use of some form of restraint. Those were the 87 cases that were included in the audit. If we look at the characteristics of the 87 individuals who died in these cases, the overwhelming majority of them were men. Approximately 3/4 of them were people of color, including 61 Black and 2 Hispanic individuals. And we also went through the case files and we coded for who was primarily responsible for applying the restraint. In just over 3/4 of these deaths, the restraint was applied exclusively or primarily by police. In the other 19 cases, restraint was primarily applied by other individuals. That could be EMTs, security guards, bystanders, friends, family members, and so forth. Okay. The ultimate goal here was to have these case files independently reviewed by unaffiliated experts to see if those unaffiliated experts reached the same opinion about these cases that OCME had reached. Before we did that, however, we had to carefully prepare these case files. Now, again, we passed along everything that OCME gave to us to the independent reviewers, with the exception of documents that were clearly irrelevant, things like cover sheets of faxes and funeral arrangements and those sorts of things that wouldn't have any bearing on the death investigation. But we also, for obvious reasons, wanted to keep our reviewers unaware of certain information that could be potentially sensitive or potentially biasing. So before passing these case files along to our reviewers, first thing we did is we redacted all personally identifiable information about the decedents, about the decedents' families, and also the OCME staff who worked on the case. Because if the reviewers happen to know those people, we don't want them to have any preconceptions about the quality of their work. We also, given that one of the charges we were given was to look for any evidence of racial bias, we wanted our reviewers to render their judgments without knowing the race of the person who had died. So we went through these files and we redacted any mention of the person's race or any factors that might be suggestive of the person's race that were not medically relevant. So you can see an example of that in this first slide here. The body, or the first sentence rather, the body was that of a well-developed, well-nourished, unclad blank male. I do not know if it says white or black or something else behind that redaction. Neither did our reviewers. That is exactly the point. The third thing we did with these case files is the majority of them, for obvious reasons, included photographs of the decedent, photographs from the autopsy, which naturally would give away the decedent's skin tone. So that presented a problem, right? It's obvious that we want our reviewers to be able to see the autopsy photographs, to see the injuries and such, but we also don't want them to be prejudiced by knowing the decedent's race. So the solution we came up with was to present the case files in two parts. Initially, our reviewers received everything in the case files except for the photographs. They rendered their opinions based on the information that they had. Then and only then did we reveal the photographs. We gave them an opportunity to change their opinions if they so chose in light of the information that they gleaned from the photos, which, as I'll explain in a moment, was actually very rare that happened. And then they locked in their final opinions about cause and manner of death based on all of the available information. Finally, obviously, we didn't want them to know what OCME's original determinations were, so we initially redacted those, and then once our reviewers had formed their own independent opinions, we revealed those and gave the reviewers the opportunity to comment on them. Who were the reviewers in these cases? As you might imagine, we were very, very, very selective in terms of who served as reviewers here. We wanted folks who were not only squeaky clean from a conflict of interest perspective, but also very, very highly experienced. We ultimately contacted 15 different professional organizations who sent out solicitations on our behalf, including NAME, the National Association of Medical Examiners. We received a few dozen applications. After whittling down based on qualifications and real or perceived conflicts of interest, we ended up with a final group of 12 case reviewers who reviewed these 87 cases. As you can see here, 7 of those case reviewers were women. The other 5 were men. 7 of them were based in the United States. The other 5 were based in other countries, namely the UK, Canada, and South Africa. With respect to the race of our reviewers, exactly half self-identified as white, the other half identified as people of color. And perhaps most importantly, they were all actively practicing, highly experienced, board-certified forensic pathologists themselves, many of whom had experience as either chiefs or deputy chiefs in their respective jurisdictions. On average, they had been practicing for 14 years with a minimum of 6 years of experience. So this was a really, really highly qualified group of folks who we recruited to review these cases for us. Okay, most important slide. I'm going to walk you through the audit's procedure from start to finish. 87 cases included in the audit. Every week for 11 weeks, we selected a random 8 of those 87 cases, and we sent each of those individual cases to a randomly selected 3 of the 12 reviewers. So each case was independently reviewed by 3 experts. The only constraint was that each expert received exactly 2 cases per week, no more, no less. And each case was reviewed by at least 1 domestic and at least 1 international expert. Each of those 3 reviewers, as I mentioned before, first received the entire case file minus any photographs or videos that existed. They reviewed that information on a secure web page. They provided their opinions on the quality of OCME's investigation, as well as their opinions on the cause and manner of death in that particular case. After they registered those opinions, we then revealed the photos and in some cases videos of the decedent that existed. We gave them the option to revise their previous opinions if they so chose. If they did that, they also had to explain to us exactly why they changed their opinions. As it turned out, that only happened about 3% of the time. So it was very rare for them to change their opinions even after seeing the photographs. When they did, they cited information that they gleaned from the photographs that had not been included in the autopsy report. For example, additional injuries, obesity, other relevant medical conditions that they weren't initially aware of. They then locked in their final opinions. So at this point, each case file has been independently reviewed by 3 experts, each of whom independently provided an opinion about the manner of death. Once all 3 of those opinions were submitted, we compared them against each other to see if the 3 experts assigned to that case did or did not all agree on what the manner of death should be. If they did not agree, we scheduled and hosted an online consensus meeting with the 3 experts that were assigned to that case, and we gave them an opportunity to discuss the case with each other to see whether they could reach a consensus opinion about the manner of death, while also making clear that that was not required for them to reach consensus. If all 3 reviewers already had reached the same manner of death opinion, that consensus meeting wasn't necessary, right? So in either case, the final step was we independently sent to each of those 3 reviewers the autopsy report, but now they could actually see what OCME's original determinations of cause and manner were, and we gave them the opportunity to comment on those, specifically whether they believed that they were reasonable, meaning matters on which reasonable experts might disagree, or if they were not reasonable, if they were medically inappropriate. Okay, getting into the findings. The most important analysis that we did, obviously, was comparing OCME's determinations for these 87 cases against our independent reviewers' unanimous opinions of those same cases. So in a moment, this table is going to populate with numbers. It's going to show you the degree of correspondence between those 2 judgments. In the rows here, we have OCME's original determination of either homicide, accident, natural, or undetermined. Across the columns, we have the reviewer's consensus opinion of those same cases, homicide, accident, natural, undetermined, or some cases where they did not reach consensus. Here are those numbers. Let me walk you through what I see as the most important takeaway messages here. First, as promised, there were a total of 13 cases, about 15% of the cases, where even after discussing the case with each other, the 3 reviewers assigned to that case could not all agree on what the manner of death was. Perhaps not surprisingly, most of those cases, 11 of the 13, had also been classified as undetermined by OCME, which suggests to us that those cases were probably particularly complex and or the documentation was just insufficient to reach any other conclusion. Moving now to cases where there were definitive opinions, these numbers along the diagonal indicate cases where our reviewers agreed with OCME's determination. That happened for just over 1/3 of the total number of audit cases, including notably all 12 cases that OCME that had actually certified as homicides, our reviewers agreed were correctly certified as homicides. However, if we take a step back and we think about that concern raised in the open letter, that there may have been cases that should have been classified as homicides that were not, there were 4 times as many cases judged as homicides by our reviewers compared to the number that OCME actually certified as homicides. So the 48 cases that our reviewers believed unanimously should have been certified as homicides included 12 that OCME did certify as homicides, as well as 36 others that our reviewers believed should have been classified as homicides, but were not. These are the cases that are of the greatest concern, right? These are the cases that can obscure the sorts of public health risks that we were talking about a little while ago. 36 cases that our reviewers believed unanimously these should be homicides, but they were not. We'll come back to that a little later. Let's now turn and talk about our secondary aims, evidence of bias. Was there any evidence in these data of racial and or pro-police bias in OCME's determinations? Now, to look at that possibility, here's what we did. We focused exclusively on the 48 cases that our reviewers believed should have been classified as homicides, 12 of which were, 36 of which were not. And we looked to see whether there was a stronger undercounting of homicides for certain racial groups than others, or for certain types of cases than others. So if we look at those 48 cases, these are the 48 cases, again, that our reviewers unanimously believed should have been certified as homicides. 16 of those cases involved the deaths of white individuals. The other 32 involved the deaths of black individuals. Now, of these 48 cases, how many did OCME actually certify as homicides? They certified 44% of the white deaths as homicides, but only 16% of the black deaths as homicides. So, and remember, our reviewers made these judgments by and large without knowledge of the decedent's race. Now, it's important to note that we cannot definitively say, given the retrospective nature of the audit, we cannot definitively say that it is race per se that drove these findings, right? There may be other systematic differences between these subsets of cases that provide competing explanations for these statistics here. However, I can also tell you, and this is not included in our report, we have subsequently gone back through these cases and ruled out a few of those competing explanations, things that are risk factors for sudden death during restraint, such as drug intoxication, pre-existing medical conditions, obesity, and so forth. So while we have not ruled out every possible competing explanation, we have ruled out several that are prominent. So the implication here is that, again, consistent with the concerns expressed in that letter, that OCME undercounted homicides in general, but they undercounted homicides even more dramatically for cases where the deceased was a black individual. We took a similar approach to looking at the possibility of pro-police bias. Of those 48 cases that our reviewers believed were homicides, 13 involved restraint by non-police actors. The other 35 involved restraint by police. We saw a similar pattern here. If the restrainers were not police, OCME certified the death as a homicide 54% of the time. If the restrainers were police, that number dropped to 14%. So again, one possible explanation for this is that cases involving police restraint were treated differently. A second possible explanation is that cases involving police restraint were in fact tangibly different from cases that did not, right? And again, because we could not blind our reviewers, to who was applying restraint in these cases, it further complicates interpretation of these results. All of those other caveats that I mentioned a minute ago here still apply. There were no differences in drug intoxication, in other pre-existing medical conditions, risk factors, but we can't rule out every other possible alternative explanation for this. Lastly, we've talked exclusively so far about manner of death. Let's touch briefly on cause of death, particularly a very controversial term called excited or agitated delirium. As I'm sure many of you know, excited delirium is a term that's been around since the mid-1980s. It's been used as a explanation for deaths in police custody. It's been criticized for being applied in a racially biased manner. And more recently, it has been thoroughly discredited and rejected by most major medical organizations, including, as you can see here, the American Medical Association, as well as NAME, the American Psychiatric Association, and many others. We wanted to look at these 87 cases and get a sense of how frequently OCME was attributing deaths of people in custody to this now discredited concept of excited delirium. And as it turns out, they did so quite a bit. In nearly half of the cases, in 42 of the 87 cases, OCME's cause of death statement mentioned excited or agitated delirium or some variant of that term. And whenever OCME attributed a death to excited delirium, they almost invariably certified that death as undetermined, right? Only once did they invoke the concept of excited delirium and then rule that death a homicide. Now, when we went back and looked at how our reviewers evaluated those same 42 cases that OCME attributed to delirium, our reviewers believed that 60% of those cases should have been classified as homicides. So what we're seeing here is one reason, but not the only reason, for that observed discrepancy in homicide determinations that we saw earlier, right? To be exact, of those 36 cases that our reviewers believe should have been classified as homicides but were not, 24 of them, exactly 2/3 of them, were cases where OCME invoked the concept of excited delirium. So this is a reason, but not the only reason for the undercounting of homicides during this time frame. Real quick to summarize the key findings here. First, there is some indication that OCME did systematically undercount homicides during the audit's time frame, particularly if the decedent was Black, and particularly if police were involved in applying restraint. I should also briefly mention that the race of the decedent was not actually associated with who restrained them. So those two factors were not significantly overlapping with each other. OCME frequently made use of the term excited delirium, and they almost always certified those deaths as undetermined, whereas our reviewers thought most of those deaths actually should have been classified as homicides. We conclude our report with 3 sets of recommendations, which I'll go through really quickly here. One set for death investigators per se, for OCME, one set for policing practices, and a third set for attorneys and folks like us. The first 2 recommendations for OCME are simple. Get in line with the recommendations and the standards of your national governing body, NAME. Abandon the use of excited delirium, which I'm proud to say OCME has since done. So by the time we made this recommendation, it's actually something they had already implemented. And adhere more closely to NAME's but-for principle. If a death resulted at least in part from the actions of another human, that death should rightly be classified as a homicide. Again, it does not necessarily imply criminal liability or wrongdoing, but it's important for public health reasons to document the manner of death appropriately. Other recommendations, I'll again go through these quickly, pertain mostly to quality assurance and transparency. We looked carefully through the qualitative comments that our reviewers offered about the quality of OCME's investigations, and we saw a number of recurring themes, one of which was a need for more and better autopsy photographs. There's also an obvious recommendation for OCME staff to remain up to date on the latest scientific understanding of restraint and the physiological consequences of restraint. Our understanding of restraint has evolved quite a bit. and continues to evolve. So it's obviously important that medical examiners are making those decisions based on the most current scientific knowledge. Our reviewers noticed that there was, in some cases, unexplained variability in how OCME handled otherwise very similar cases. So we called for greater standardization of the procedures that they follow to make sure that there aren't judgment calls being made that might be inappropriate. And finally, expanded QC procedures, things like internal peer review, external peer review, and so forth, to make sure that these judgments are reproducible. With respect to recommendations for policing, without question, the number one theme that we identified in our reviewers' responses is that medical examiners will be able to make more reliable decisions about manner of death if they have better and better quality information about the incident, about the restraint. Medical examiners need to know, for example, the duration of the restraint, the nature of the restraint, the decedent's body position while being restrained, the decedent's behavior while being restrained, and so forth. That information was often lacking in these files. So one big recommendation for us is to maximize the amount and the quality of information that medical examiners are getting about the medically relevant parts of the restraint. Now, one way to do that, obviously, is through firsthand accounts, right? A problem with that is if those accounts are given by individuals who were involved in the restraint, those accounts may be unreliable or less than complete. So ideally, accounts would be taken verbatim rather than filtered, and accounts would be taken from individuals who were witnesses to, not participants in, the incident. An even better solution, though, would be the provision of body-worn camera footage. Of the 87 cases included in the audit, there were actually only 2 cases for which video footage existed. And that's not enough, right? And that was, again, a common comment by our reviewers was it would be helpful to see what actually happened here because I have incomplete and or conflicting information. If I knew what happened, I'd be able to make a better judgment. It goes without saying that police should be receiving training in appropriate, meaning non-lethal restraint techniques, techniques that are developed in collaboration with medical experts to be safe but effective. And even better, if we can involve mental health experts in responses to individuals in crisis. A lot of the decedents in these 87 cases were individuals who were under the influence of drugs or alcohol and or were experiencing mental illness, right? Having people who have specific training in dealing with those sorts of situations, in de-escalating those sorts of situations, can be a real asset. Hopefully de-escalating to the point where the use of restraint isn't even necessary in the first place. Finally, for the Attorney General, who, again, sponsored this whole endeavor, we recommended reviewing the 36 homicides that ACME seemingly misclassified and determining whether any additional investigation or any additional action is warranted on behalf of the affected families. That is something that is currently underway. And, you know, I'll conclude by saying, and this is a large reason why I'm thrilled to be here today, is when we were designing this audit, we were doing it for Maryland. But every decision that we made, we knew and hoped that we were providing a blueprint for other people to follow, that we were writing a recipe that other people could emulate. So it is certainly our hope that other states will see what we've done and look in the mirror themselves and undertake similar audits, because we have really no reason to believe that any of the issues that I've discussed today are unique to Maryland, right? These are systemic issues. And the extent to the extent that we can expose how widespread there are, it will be easier to address them. I really just kind of scratched the surface today in terms of talking about our 70-page report, which is publicly available online. If you're curious, there's a lot more information on there. We are still a little ahead of schedule. So I will turn it over to Anne Marie, and thank you all for your attention.
Thank you for viewing this presentation from the Conference of the National Association of Forensic Science Boards held in New Haven, Connecticut at the University of New Haven in October of 2025. The mission of the NAFSB is to disseminate and exchange best practices, research, expertise, data, and lessons learned among state-level forensic science boards and commissions governing the forensic science community. I encourage you to visit our website at www.nafsb.org to learn more and we look forward to your support for our work.